Hello friends, in the series on income tax cases, today we will discuss a very important case which becomes also important nowadays because a number of additions are being done on the basis of some Excel sheet which are found at the premises of a party which is being searched. The issue before the Jaipur ITAT in the present case was that whether the addition can be done just on the basis of a spreadsheet which is an Excel sheet which is found at the premises of some other persons without the following the procedure which has been given under section 65A and 65B of the Indian Evidence Act 1872, especially in those cases where the amounts written on in these Excel sheets show that the amount has been received after 19 months of sale deed. This issue has been taken up by the Jaipur ITAT A bench in the case of Anshu Sahai, Hindu Undivided Family versus Assistant Commissioner of Income Tax, and this case is reported in 135 ITR Tribunal at page number 45, and the date of the judgment is 3rd November 2025. In the present case, it was the allegation on the assessee that the assessee has sold various properties and the assessee has received over and above the amount which is mentioned in the sale deed, and this allegation was based on the basis of an Excel sheet which has been found in the computer of some other party which has been searched. When the assessment proceedings were going on, the assessee was confronted with this Excel sheet, and it was the submission of the assessee that it has been alleged that the assessee has received the amount in cash after 19 months of the sale deed. It was the submission of the assessee that no party will give to other party any cash after 19 months of the sale deed. The assessee said that when the sale deed is made, there is no legal obligation on the other party to pay the amount, and it was the submission of the assessee that there is no receipt which is in the handwriting of the assessee which the assessee has given after the receipt of the cash. But the assessing officer was not convinced with all of these submissions and go ahead with the addition of the amount which was being alleged being received in cash over and above the sale deed. When the matter was before the CIT appeal, the CIT appeal also upheld the order of the assessing officer more or less in verbatim. When the matter was before the tribunal said that in the present case the Excel sheet was found which is a digital document. The tribunal said that the cash has been alleged to be received after 19 months of the sale deed, which is highly improbable. The tribunal was of the very considered opinion that in the present case the revenue has not initiated the proceedings under section 269 ST against the assessee for receiving the cash of such a big amount in cash. The tribunal said that there is no signature of the assessee on any paper which shows that the assessee has received cash of such a big amount, and it was also the viewpoint of the tribunal that since there is no obligation to make any payment after the sale deed, so it is not probable that the assessee has received this amount of cash. No cross-examination was given to the assessee. The amount was written in multiple of hundreds, which is also not justified for such huge payments. The tribunal said that in the present case, the additions have been made on the basis of loose sheets, dumb documents which do not have any corroborative evidence, and since the spreadsheet is a digital document and the section 65A and 65B of the Indian Evidence Act 1872 has not been followed at all, so the reliance on the digital spreadsheet is unacceptable. The tribunal said that in the present case the Excel sheet has not been found at the premises of the assessees, so in that case also the credibility of that Excel sheet is very much doubtful. In the present case, the assessee's exemption under section 54B has been denied under section 153C proceedings. For that, the tribunal said that since that exemption was allowed to the assessee in the earlier proceedings and there was no clinching evidence or incriminating evidence in the search which suggests that the assessee has claimed that exemption in a wrong manner, so even that exemption cannot be denied to the assessee. So in nutshell, the present case suggests that the addition should not be made on the basis of a spreadsheet which is uncorroborated and for which there is no voucher or receipt which has been signed by the assessee, which are being referenced in that Excel sheet. At the end of this video, once again, I am repeating the name of the case. The name of the case is Anshul Sahai Hindu Undivided Family versus Assistant Commissioner of Income Tax, and this case is reported in 135 ITR Tribunal at page number 45, and the date of the judgment is 3rd November 2025. Thank you, friends.